Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican, please. Verbal slaughter.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. Fat and happy after making the successful trip to my local Mickey D's. Got chocolate shakes for the family and a Big Mac for myself. So there goes the diet for the year. Made it this far. Boom, it's gone. All right. Welcome. Thanks all for being here. We're about to go back to court. I have to say, first and foremost, thank you, Kim R, for being first in chat today. Your promptness, your punctuality is going to be met with punishment. Everything IP related worldwide is your responsibility. You're going to do great, though. Congratulations. Thanks for being first in chat. This goes on your permanent record. All right, as we are about to kick things off, let me get the commands working here. Let me get that running. And just want to let you know the snowplows are out in force in my neighborhood. Yes, snowplows are out in force, pre-treating the streets because we're expected to get some snow this weekend, which my kids cannot be happier about. Did I use my app? No, the app didn't work. I had to drive around just like he did. So frustrated. I ended up just ordering from the drive-thru. Can I take your order? I ordered through that one. I ordered through the menu system. So, all right. Now let's go to court because it's time. As I say, it's time to go to court. Regina, thank you. Thank you. It arrived. I was going to tell you. Thank you very much. They're super excited. Regina got my kids some rainbow PLA with a 3D printer.
So you can take the stand, please.
And I think my daughter's printing something right now. I don't know what she's making, but she's already printing something. I can't wait to show you. Quick Panic buy milk and eggs. The toilet paper delivery is coming today. We've ordered some already. We got 8 gallons of milk yesterday.
Yes, ma'am.
60 eggs.
Can you just get
Yours first. Yours is fast.
Everybody have microphones, please. Thank you.
Okay, hang on.
All right,
Stop.
Yes, sir.
Stop.
Judge, there was an exhibit in Commonwealth's Exhibit 159.
159?
Which was the firearm sale purchase, and there was some information that...
159, I have firearm transaction record.
Yes, and there were social security numbers and other identifiers on there, and I'm just asking that they be...
Want to redact the social security numbers?
That's fine, and I can provide the court with a redacted copy to
We'll
replace.
provide it with a redacted copy, okay?
Okay, awesome. 159.
159.
Thank you.
We'll get that. All right. That's all you have, Mr. Carroll?
That's all I have.
All right.
I have information. Judge, during the break, a gentleman approached one of our detectives in front of 2 jurors and asked if it was too late to testify. The detective instructed him at that moment to stop speaking, and they walked away, and that was the extent of it, but that would have been overheard by 2 of the jurors.
All right.
Whoa.
May we approach, Judge?
Okay.
Yes, please. May we listen in, Judge? This gets spicy. This is like a complete repeat of this morning. Almost identical. They both have 2 issues. His is shorter. He takes care of hers. And she comes up and says, oh, by the way, we have another witness. Only this time it happened in front of 2 jurors. Let's see. Who do I owe a thank you for this? I can't even read it. I can't find who the thank you is from. It's got to be in here somewhere. There it is. Regina, this is the one.
All right, are we ready for the jury then?
Thank you.
Yes, ma'am.
Okay.
Another one. We've got plot twist after plot twist happening here. Oh wow, look at this. This is yellow on one side and red on the other. So it's a 2-tone PLA for the printer. They are going to love this. Thank you so much, Regina. I can't wait to show you what they print.
Thank you.
No juror voir dire. Let's see. Let's hold for just 1 second as the jury comes in. Let's pause now for station identification. 3, 2, 1. You're listening to Recovery Addict live stream on YouTube. There we go. Okay. Beautiful. Okay, so we kicked it off with Spice. We now have potentially 2 more witnesses.
Thank you, Your Honor. Mr. Banfield, you were asked on cross-examination as to your decisions relating to calling 911. At what point did you feel like 911 was necessary?
I guess once I was in the room, I knew that 911 was going to be necessary.
And at the time that you realized that, were you capable of calling 911?
No, my hands were on my firearm.
Okay, and so when you're saying in the room, you'd already confronted Joe Ryan?
Yes. Yes.
Okay.
Yes,
and,
just yes.
Was there any other time that you were in a position to be able to call 911?
When I was rendering aid, I had instructed Juliana to call 911. I believe that was the best course of action at the time.
But you weren't able to call 911
Objection
yourself.
leading.
Sustained deleting.
What prevented you from calling 911 yourself?
I was rendering aid to Christine.
Now, Ms. Sands asked you if there was any information out there that related to fetish-type behavior that you knew of Christine being involved in. And
she's not here to defend herself.
Back in New York, I know that Christine had an affair where she was involved in a BDSM relationship for a month or 2.
And how did you know to talk to her about that?
She was in our bedroom in New York. I observed her with bruises, several of them on her body that I was unaware that she had previously.
And did you ask her about that?
Yes.
Did you have a discussion with her about that?
Yes. Originally, she denied it and said.
Objection, hearsay.
You can't say what she said.
Okay.
But you confronted her about it?
Yes.
Okay, and what, if anything, did you suggest she do after being told?
I suggested that we go back to therapy. At that point, I questioned her enjoyment of it. It was pretty emotional conversation.
And in fact, were those the things that you indicated that you were unwilling to do?
Objection leading.
What, if any, of those things?
Same question, same objection.
Were you aware of the things that were related to this New York incident?
Yes, she had. Christine was interested in, I guess, sexual violence. She was a sexual assault nurse examiner. She did many examinations of both men and women that were in people that were injured, people that had a lot of people that were choked, people that were raped, some pretty graphic things. She used to bring some of her documents home, so I was aware that she she seemed to look at them relatively often.
Okay, and so, and I'm sorry, can you tell me what year was this?
She was a sexual assault nurse examiner. This is an estimate, I guess, from like 2012 to 2017, 2018.
And the incident that you're talking about with regard to her experience, when was that?
With estimate to 2014.
And is it your testimony that that's when treatment took place?
Objection leading.
Sustained.
When did treatment take place in relation to that date?
I believe that we went to counseling in 2013 and again in 2014.
And as far as you can tell, were there ever any other incidences where she was involved in something like that?
She had indicated that there was a...
Objection hearsay.
You can't tell what she said.
Okay. I'm aware that there was another brief relationship where she was stalked for a few weeks.
And were there, how were you alerted to that?
She was frightened of that person.
Objection non-responsive.
You're overruled this one. Next question.
Were there any injuries related to her, relating to that situation?
No, I'm not aware that she was injured in that situation.
Okay, and the previous one that you talked about, were there injuries?
There was significant bruising to her legs, to her buttocks, to her chest.
Did you notice any physical changes in the way she carried herself as a result of that?
Objection leading.
Sustained.
What, if any, other physical clues were there that this was going on?
She had difficulty walking. She was walking very stiffly.
Anything else?
I don't think so.
There was testimony that you testified that you broke up with Juliana prior to this incident, correct?
That she broke up with me?
I'm sorry, there was a breakup.
Yes.
And do you have any idea when that was in relation to February 24th?
I guess it was kind of complicated. She was very upset with me when Christine and I went on a vacation. We went on a cruise in November. I would say that started a lot of Juliana's anxiety and anger with me. On Christmas, she went to a hotel because she did not want to view Christmas with me and my family. She didn't want to see me, Christine, and Valerie together. In February, when Ms. Sands had brought up the messages, she had indicated that she was going back on dating apps, and that was going to be the end.
Okay, and you were trying to talk to her, is that fair?
Yes.
Okay, and so at the time that this happened, what was the status of the affair? And I'm talking about February 24th, 2003, at that time.
We were not in a relationship at that point. It wasn't that long that the relationship had stopped, but Juliana at that point had made it clear that we weren't going to be together any longer.
And so what, if anything, did you when you made the decision to shoot Joe Ryan, did you feel like Christine?
Objection leading.
Sustain.
What did you think
She's so
when you
quick with their
made the decision
objections.
to shoot Joe Ryan?
That he was an imminent danger, that he was a threat to he was a threat to Christine, and that was the best way to stop his actions.
I don't have any further questions, Your Honor.
All right. Thank you. You can have a seat next to your attorney.
All right. So he
Thank you.
Take a tiny break here while we wait for the witness to be dialed in. We're going to raise the monitor on the stand in place of the witness and connect to Zoom. Let's see if we can. We'll now, and during this witness, get to hear the recording of Lily, the dog. There's the monitor being raised. Watching chat, that was awful. That was disgraceful. How is this possible? How is it allowed? How can anybody do this to the mother of their child? Lots of similar comments where you've got someone who is unable to defend themselves, whose reputation is being tarnished, I guess you could say, quite severely, and blamed in a large part for the whole situation, with no other supporting evidence. I mean, if this was her, if Christine was into that lifestyle, I mean, I'm not judging her. Okay, that's her own decision. But if she was, why then did she not access any of it when he and Juliana and Valerie were out on vacation away from them in New York? During that time, why was she just working? Why did she do nothing on the computer that even remotely resembles this when she's finally able to, to have freedom to do what she wants without anyone looking over her shoulder or judging her or anything else? Why did she not a single thing, not a single website, not an email check, nothing? It just doesn't, his story does not hold up to reason. I do think prosecution is playing a long game here by not confronting him and letting him explain some of the contradictions in his story. They get to present them for the glaring discrepancy that they are in closing, as opposed to him being able to come up with he thought up a lie and he thought it up quick, like in How the Grinch Stole Christmas, a solution, an answer to something, when there's quite a few holes in his story. They pretty much just let him talk for quite a bit of time. Next witness, Nick Barrero. I can't remember how to say his name. Barrero. He'll be testifying remotely. We've already seen him once, but the evidence that he wanted to analyze and was going to be paid, is getting paid to analyze and explain to us, was not admissible yet until Brennan got on the stand and laid the foundation for that recording of the Lily 3. Once we have that, we can play it for this witness, and then we can also play the 911 call again and compare those sounds and see if it in fact was the husky in the background or something else. Yes, I need more Portuguese names.
He said one moment. He said one moment.
He's like, hang on, I'm busy. The witness is like, 1 second, I'm at McDonald's in the bathroom. Give me 7 minutes. What is he writing? Hopefully an apology. I don't know. Probably recounting.
Responded 1 moment. So.
It's okay. It's not like we're all waiting on you, sir. I think it's important for the timeline for when things happened, what was happening with the 911 call. Thanks to all those who like the stream. We appreciate y'all being here. I know we've got a few people who haven't been here in a while and some people who are here for the first time. The like button does not discriminate. You can all click it, and we thank you each for that. The electronic TV pedestal thingy is up.
He's on.
All right. Sir, can you hear me?
Yes, I can. Can you hear me?
Yes,
Yes, sir. All right, just a reminder that you're still under oath, okay, sir?
Yes, Your Honor.
Good afternoon, Mr. Barrero. This is John Carroll.
Hi, John.
How are you?
Please cut the pleasantries.
I'm good, thank you.
I'm going to try to start where we left off on the previous testimony. I believe we were talking about your methodology.
Yes, sir.
Now, you reference in your methodology critical listening, waveform, and spectrographic analysis.
They said they're on their way.
Yes, sir.
Can you please explain to the ladies and gentlemen of the jury what that is?
Yes. So critical listening is just a detailed, repeated auditory review of the evidence. It's using high-quality professional headphones on a forensic workstation and just reviewing the evidence in as detailed a way as possible with the ears. And that normally goes hand in hand with the waveform and spectrographic analysis, which is the visual representation on the screen of the audio that we are hearing through the ears. And the waveform is the squiggly line that everybody's familiar with. The spectrogram includes the frequency or the pitch, the individual frequencies that are present in the file, instead of just the amplitude of the sound wave in the waveform. You get the amplitude, you get the frequency or pitch also contained within the spectrogram.
And what does a spectrogram show us that our ears might miss?
So the spectrogram separates the sound into its frequency components. And so we'll see the individual frequencies that make up the sound. It's like deconstructing a symphony. You can see the individual instruments as opposed to just the sound altogether. So it really allows us to see through noise and overlapping sounds, and allows us to see audio details that otherwise you wouldn't necessarily be able to hear just with the ears. And it provides an objective measurement to use when we're analyzing an audio recording.
And, sir, in your analysis, you discuss fundamental frequency and formants. What are those?
The fundamental frequency is the lowest frequency of a sound. Typically, if we're talking about a vocal sound or a musical sound, the fundamental frequency is what we would consider the pitch of that sound. It's symbolized as F0. It's the lowest formant on the spectrogram, and the formants that accompany that, they're the overtones. They're the resonant frequencies above the fundamental frequency that really gives the whatever the sound is, gives the voice or the instrument the unique sound, because those formants are created. They are a reflection of the unique shape and physical characteristics of the vocal tract or the instrument itself that created the sound. So the reason you can hear the difference between a piano playing middle C or a saxophone playing middle C, they're both playing the exact same pitch, right? Middle C is a defined pitch, but it's the overtones, or in this case, we're talking about the formants that actually give that sound its unique characteristics that allow you to distinguish the difference between a saxophone and a piano, for example.
And, sir, you've received 2 audio files as part of your analysis, correct?
I did.
Here we go.
Okay, so there are two items in evidence. One is Commonwealth's Exhibit Number 1, which was the known 911 call. And we also have Defense Exhibit Number 378, otherwise titled Lily 3, Original. Have you reviewed both of those? Now, let's just look at the 911 call first. What, if anything, do you do regarding isolating a specific sound?
So for the 911 call, there's a sound after the dispatcher answers, which is really the only sound that I was concerned with. It's a short recording to begin with, but the sound in question is about 1.4 seconds after it's a 1.4 second clip after the dispatcher answers the phone. And so I used that 1.4 second clip for the entirety of my analysis of this tape. I didn't do anything else with, like, when the dispatcher answered the phone or the automated voice that comes on the line prior to the dispatcher.
Okay. And was this relating, were you analyzing based upon what you just explained to us, how you got to that 1.4 second clip?
Yes. So on the spectrogram, it's visually very visible in the spectrogram, as well as audible when you listen to it, that there's this sound in that 1.4 second segment. You can see the fundamental frequency at the bottom, the F0, and some distinct formants stacked above it. So that sound was easy to isolate audibly with the ears and easy to isolate visibly in the spectrogram.
And let's move on to the exemplar recording of the dog, Lily 3. What did you find regarding the fundamental frequency of that?
So there was a segment of the Lily recording that I also isolated and used for the analysis here. And the fundamental frequency for both the 911 call, that questioned sound on the 911 call, and the segment of the Lily recording, the fundamental frequencies were both in the low 200 hertz range. And then there were formants stacked above those in both recordings as well. And so I isolated each of those and put them side by side to compare not only the fundamental frequency, but also the individual formats that were stacked above that.
And what, if anything, did you do then?
So I found that in both recordings, the fundamental frequency was in the low 200 hertz range, and then I did look at the individual formants above that, and the specific the F1 and F2 formants. So the first two formants above the fundamental in both the Lily exemplar and in the 911 call. Those first two formants were the highest amplitude. And then the other formants stacked above that kind of dropped off in amplitude. And they all lined up very well in the spectrogram, meaning the individual frequencies that made up these sounds were consistent from one to the other.
And what, if anything, did you create as a result of that?
So I created what I titled exemplar 911 concatenated.wave. And this was a file that I created using the isolated segments that I just talked about. So the short 1.4 second segment from the 911 call and the segment from the Lily 911, or I'm sorry, the Lilly exemplar recording, I placed those side by side. So basically one right after the other in this exemplar concatenated recording so that it could be compared audibly as well as visually in the spectrogram and with your own ears. And so when these two sounds are played back to back like that, you can hear that when they are played back to back, it's a consistent tone. It's a consistent sound that both audibly and visually with these two samples.
And
Roll
these,
tape. Let's listen.
this concatenated wave exemplar of the 911 and the Lilly calls is something that you created based upon Commonwealth Exhibit 1, which is moved into evidence, and Commonwealth and Defense Exhibit 378 that's been moved into evidence?
Yes, sir.
You're going to move in the concatenated wave as Exhibit 379?
Any objection?
No, ma'am.
379 in evidence?
Your Honor, may I have permission to play?
Sure, do you need assistance? Because
I'm going to try to play.
Because I don't have
always
faith
need
that
well,
you'll-
your laptop's not connected anymore to the,
Oh,
I have IT
okay.
On
Thank you.
standby.
in the courtroom
I'm fine,
because,
I'm fine stepping away.
like, yes,
Judge
your
like,
reputation precedes you, Mr. Carroll.
As a technology person or not?
You're trying to play.
No comment.
So this one right here, exemplar 911.
Okay, and are you attached to the system?
I think I am.
Okay. You have a.
Am I good to go? I think I still need a small. Okay.
It's just not.
that slowed down.
Okay, it's only a short one.
Just have to move the microphone down to the laptop. There you go.
Seriously?
Okay.
You can't plug it in?
Sir, could you hear that?
That was like 25% speed.
Not really well, but I could.
Is there another way to hook into the system?
Yeah. There's a way to plug into the system.
Let's try turning it up.
Sorry. Could you hear that then, sir?
Yes, I can hear it. It's not great quality, but yes, I can hear it.
Sir, when you played these two sounds back to back, the known dog sound and the question 911 sound, what did you hear?
So the audio was consistent from one recording to the next. They sounded audibly consistent with each other, and like I said, visually they were also consistent in the spectrogram.
Now, is it possible to, using all of the tools that you have, to find a moment where the pitch of one sample is consistent with the pitch of the comparison sample, if you have a long enough exemplar?
So it might be possible, given a long enough recording, to find a moment where the pitch or the fundamental frequency matches simply by chance in a long recording. But that that would just be one piece of the puzzle. Like I said, with the fundamental frequency, that's just the start of the sound. What really gives a sound its full character are all of the formants or the overtones, like we talked about with separating the sound of a piano with the sound of a saxophone. Those two instruments, if you have a long enough recording, their pitch is going to overlap a lot, right? They could be playing the same note at the same time, but they will never sound the same because of those overtones, because of, in this case, the formants make up the sound. So we're not just simply talking about the single pitch of the fundamental frequency happens to line up at one moment in the recording. We're talking about much more than just a single moment where the pitch matches, but all of the characteristics of the sound are also consistent. So the unique sound of this groan, we'll call it, that comes from those formants, not just the pitch. So yes, while it is technically possible that you could find a moment in any sufficiently long enough recording with sufficiently variable pitches where two pitches might match, that's really not what was done here. This is looking at the entirety of those two samples for the comparison, not just that the pitches happen to cross each other at a moment.
Now, based on your forensic analysis, have you reached a conclusion regarding the unidentified groaning sound on the 911 call and the known recordings of the dog Lily?
Yes. So I can say to a high degree of forensic certainty that the apparent groaning sound on the 911 call is consistent with the dog groaning sounds found in that exemplar recording.
And would your conclusion be any different if you were retained by the prosecution?
No. My conclusion would be exactly the same, because my analysis is based strictly on the objective data, the spectrograms and the audio characteristics, not on which party is actually requesting the analysis. I tell everybody that hires me, I'm not an advocate for either side. I'm an advocate for the evidence. So my testimony would be, my conclusion would be exactly the same, no matter which side retained me.
Thank you, sir. Those are all the questions I have. The Commonwealth may have some questions.
Why didn't you play it at actual speed? Play it at actual speed. It's going to sound different.
Good afternoon, Mr. Barrero. Thank you so much for your time today again. Just a couple of questions for you.
Good afternoon.
Isn't it entirely possible that the sound that we hear in the background of the 911 recording could also have been a human making that noise?
It's possible, yes.
Okay.
No further
and
questions.
You were given a 1 hour and 25 minute long segment of Lily, or a sample of Lily, to compare to the 1.4 seconds of 911 call. Is that correct?
Yes, ma'am.
Okay. And in the approximately 5,100 seconds of Lily groaning, you found what I think I understand to be a 6-second sample that matched. Is that correct?
No, I wouldn't characterize it like that, because much of that exemplar, there was no groaning. There was only a few tiny segments in that whole sample where there was any groaning.
Okay. And this was titled Lily 3 audio. We heard the defendant testify that there were as many as 3 different samples created. Were you given samples 1 and 2 to compare?
No, I wasn't.
All right. Nothing further, Judge. Thank you.
All right, redirect.
Do you speak dog, sir?
Mr.
What did the
Barrero,
dog
just
say?
to be clear, the item Lily 3 was nearly an hour long, correct?
I don't remember the exact time, but But yes, it was a much longer recording than the 911 call.
And it was recorded, or it was left recording in order to get
Objection
sound.
leading.
Sustained.
Is it fair to say that there were numerous sounds on there, but not a continuous?
Objection leading.
Sustained.
What did you find with regard to the Lily 3 recording?
There was a lot of relative silence, so no real sounds at all, just kind of background noise. There was some barking and whining and other sort of dog sounds, and like I said, just a few groaning sounds in the entire recording.
And when you choose your exemplar for purposes of your forensic analysis, you have specific goals in terms of making it a good comparison, correct?
Yes. So clearly, it wouldn't be beneficial to take the time to compare a barking sound with a groaning sound, right? Because those are immediately, obviously, not consistent with each other. So I specifically was looking for a groaning sound because that's what is audible on the 911 tape.
And no one directed you to the sounds?
Objection leading.
Did anybody direct you to the sounds that you ultimately chose in order to use as a comparison?
No, sir. I was given the entire file, and I chose the segment that I used for the comparison.
Okay. Thank you, sir.
All right. Thank you, sir, for your time.
And with that,
thank you.
The defense says,
Thank you, ma'am.
here we go.
All right. Your next witness?
The defense rests.
They rest.
Defense rests.
Boom, they're
All
done.
right. Why don't we go ahead and take our break? Let's go ahead and take our 15-minute break before we do rebuttal evidence, okay? It's a little early, but that's okay. We'll come back at 3:15, okay? Just don't discuss anything and don't do any outside research, okay?
So who could be on a rebuttal? Could be Juliana. There's a handful of people, witnesses that could be pulled back in. We see the defense expert still there in the courtroom, even though he's been released. I guess he's still clocking those billable hours. The podium's being lowered, the lectern. We may hear from two new witnesses. T. Patrick Smith, bring in the T. Possibly, we think this may be a co-worker of
There we go.
Brendan.
All right.
At the
I
IRS.
assume the rebuttal evidence will be finished today then?
Judge, I have 10 minutes with one witness and 5 with another.
Okay, that's good. Well, then they get their break and they can come back and then we'll just let them go for the day.
Okay.
And then we'll go ahead and do our jury instructions and
Yes,
take
ma'am.
care of that as well, okay?
Yes.
We're
And
almost done.
Then we'll be
We're
ready
almost
for...
done. 15 minutes.
But we have the 9:30 media motion?
Yes.
Yes.
Okay. And then at 10 o'clock, we will be able to do closing arguments. Do we agree?
What's the media motion?
Perfect. All right, let's just come back then at 3:15, okay?
Okay, thank you.
What's the media motion? Excuse me? Excuse me. I have questions. The defense is rested. They are done. They are done. Now we get to either hear from Juliana, again, who is still on recall, or possibly these two witnesses. Two people have come up to the defense saying, wait, I heard something in this case, and I have evidence to the contrary. They obviously were not on the witness list, or else they would have been excluded. They wouldn't be allowed to watch because they're not on that list. It does present some problems because they did listen to the testimony, but that's not something that's insurmountable. Obviously, if we remember the burn pile case where we had someone watching our channel that heard something during the trial, and because of some things we said, felt I need to call the prosecution and let them know. So this thing does happen. It does happen. And we've got two people now. One of them in front of two jury members and one not. Although it could, in theory, it could be the same person. It could be T. Patrick Smith who's there. Is like, is it too late to testify? Are they done? Why am I here? Could be the same person, but could be the first au pair. Looking forward to a Friday verdict. I think we're still going to hold to Friday. I don't know. With the court being done with evidence right now, I think the judge would be more inclined to let them have Friday off instead of working Friday. But we'll see what she says at the end of today. to the jury when she dismisses them to see. I do have to tell you, just talked with Thomas on the text over lunch. He's not feeling the best. He's a little under the weather, and he's got some repairs related to the weather that he's got to do as well. So we are going to cancel the podcast tonight. I apologize. I know that's the highlight of many people's week, as it is mine. Under the weather watch, yes. But we're going to cancel the podcast for tonight, which will also give me time to go out into my Airbnb attic before my renter arrives tomorrow and insulate the pipes so they don't freeze again. So everything's it all works out. It works out for Thomas. It works out for me. But we'll have to put a pin in the podcast for one more week. It's okay. You can go back and watch last week's. It was great. So do we get AI Thomas instead? I have not yet cloned Thomas. It's hard to do that. He's quite the gentleman. AI just can't quite pin the personality. Let's see. Podcast is like birthday form today. Let's see. I think the judge said 9:30 meeting motion. I thought she said media motion. There are media motions, but did you get the video of the dog howling? I did not, but what I did find, hang on one second, is I found some more tech that I think I need now. I'll show you on my phone once we go full screen here just for a second. This guy is a graphic equalizer. It's a visualizer for sound. So some of the stuff that this witness was talking about just a short while ago was about the spectrum, the visualization of sound. This is not waveform, but it does give you the range of frequencies, and you can see where the sounds are. This helps a ton, absolute ton, when I'm tuning out problematic frequencies in court. Say there's some noise in the background. There's a high-pitched whine from the air conditioner, or something like that. Even if it's just like a microphone's picking up a certain chair squeak or a door squeak, I can use one of these to pinpoint the sound a little bit better instead of manually just trying to find the sound and eliminate it for you. But I will say the last witness does know what he's talking about. Everything he said was true. He looked at a very narrow data set and came to that conclusion. And you heard him say that it was consistent with the dog. He found a tiny bit where, and we listened to 6 seconds of if we remember right, the sound we heard, I didn't hear the 911 call. I think we heard Lily for 6 seconds going with that moaning sound. And now the jury's just supposed to remember the 911 call and what they heard there. They didn't play it side back to back. So sounds like you're justifying it to Mrs. R.A. It's a business expense. I don't have to run it by her. Yeah, I just need spectrum is all, Lee. I'm looking for a good. I wish it had more channels. I wish it had like 80. I'd like to be able to break down the frequencies even further, but. All right. With all the cases we've watched, do you think you could be attorney no, and hold your own courts? No, honey Trish. I think with all the cases I've watched, I've learned that I would not want to be pro se. I definitely would not want to be my own attorney. If there's anything, if my freedom when life is on the line, I'd want somebody else who was very experienced and can remain calm when they aren't in the hot seat defending me. I would not want to be an attorney for myself. Let's see. RA got lots of play money the other day for that equalizer. I think we'll be able to cover it, Red Pen. Thank you. It's only about $50, so it's a lot. It's a lot for a little screen. It's a $50 screen with no buttons. Okay, so, but it will help. I haven't found one at Sweetwater. I haven't found one. This is actually through eBay, so. If you can find a better one, let me know. No rebuttal for the state. Yes, there is rebuttal, Stacey. It's coming up next, right after this break. As soon as we come back, the state has 2 witnesses. One is 10 minutes, one is 5 minutes. It's going to be fast. I hope it's spicy. We think that one of them is in direct, opposition to testimony we heard from Brendan yesterday. He reached out to the prosecution and said, "Hey, here am I. I know otherwise. I know he lied to you, and I can prove it." So we'll get him. I think that was T. Smith spilling the tea here in a little bit. See, I feel like I might be able to do small claims, but I don't want to. I think some courts don't allow you to have lawyers in small claims. Make your own with Arduino and display. I could, and we do have a handful of Arduinos and, Raspberry Pis and things like that. I've even got a NVIDIA Jetson. I think it's the Jetson Nano. I forget what it is. We've got a few little processors that could do things like that. But when would I find the time, Lee? And it wouldn't look nearly as good as this one, which was beautiful. Debbie, thank you. We do have the best mods chat and a halfway decent host. I appreciate you including that list. Let's see. Camilla said you sent it to Top Mark. That's why I hadn't seen it yet. Give me just 1 second. And Camilla, I think you said you had a husky, right? Okay, there it is. Oh, we've got a call coming in. Hold, please. Let's see if this is relevant to the things at hand.
Call from Angela. Call from.
Hey, Angela, are you there?
I am here.
How are you doing?
I'm doing good. You?
I'm doing well. Should probably get on Discord, shouldn't I? But go ahead.
I still have Viber, so whatever.
Yeah.
What I wanted to say, I'm going to just go straight to, I did not believe a single word he said on direct, and there are times when he clearly, since he was breathing into the mic, that his breathing was shaky.
Oh, very much.
I don't know if it was just me.
It was like almost his chest was convulsing type shaky.
Yeah. And I did not believe a single word he was saying. Something that he also said, you also said, but something that was mentioned, I don't know where, doesn't really matter where. Like when allegedly was Christine on Fat Life, you said sometimes it coincided that she and babysitter or au pair was at the house.
Right.
But other times, like you said, there are not. She was alone, home.
Yeah.
She could have had men over for whatever reason. And what she was messaging them, by whatever reason, clearly what she was messaging with Mr. Joseph, I don't know his last name,
yeah.
Which also brings me,
Joe
why
Ryan.
is he calling him Joe? His name is Joseph. Why is he calling him Joe? Were they friends?
No, they'd never met or talked before he was at gunpoint, apparently. It frustrated me so much of that. The blaming, the victim shaming that went on there. There's so much of this whole testimony from Brendan that has, anytime something bad or nefarious comes up, it was her idea, whether that's Juliana's or Christine's. It's never him. This guy is a knight in shining armor riding a white horse into the sunset. He has no flaws. He has no problems whatsoever in his life. He's perfect in all of his stories. Which nobody is. It just makes his story that less believable. And
yes. Also something that he said on redirect, and I was reminded in the chat that he also said that yesterday, although I definitely missed it, even though I watched the whole thing yesterday, his direct, that he was, hold on a second. Yeah, whatever. My brother just being annoying as always. He was... hold on a second.
Just don't commit any felonies there. I know they can be annoying.
Yeah, I gotta go.
Okay, I'll catch you later. Thanks, Angela.
Bye.
Bye.
Bye-bye.
Brothers. Lee, thank you for that. That link is awesome. Way outside of my price range, but man, does that look cool. They both blamed each other for everything, but Lizzie, he did not turn around and blame the plan on Juliana. He blamed the plan on Christine, on the victim, and it just does not add up. I'm sorry, you tell me that she is an SA abuse investigating nurse, okay, that like she works with people who have been treated just absolutely horribly in the most terrible ways known to man. And she works around that, and she's like, yeah, that's the thing. I don't buy that. I don't see that she sees victims day in and day out, and that becomes the turn on for her. I'm sorry. If her, I'll say it, if her mind were that depraved and that polluted and gross and in the gutter, where is all that activity when Brendan and Juliana are gone? Why isn't it just her? Why isn't her history on her Google search filled with this stuff? Why isn't there some other evidence outside? Why is there nobody else that goes along with the story that he told about what she's really like? Why does nobody else know if this is what she's like? It just does not ring true at all. Jody Callahan, what brand filament do you use? I got an awful batch, probably not sealed well. My daughter loves these things. Keep up the good work. We've got a variety of filament, and it's all worked well, but it's all been PLA so far. And part of that is we keep our house, the humidity in the house fairly low. It's under 40%. So maybe in the summertime here in the South, when the humidity goes up, the PLA is not going to work as well. That's for the 3D printer. That's what that question's about. AWOL Podcast says 2 months to go for the Pink Courthouse. Remember, it's free to show love, but expensive to hate. So don't do the latter. Been an OG, but want my stripes. AWOL, you are an OG. Appreciate that. Let's see. If her mind were that depraved, she would marry a narcissist like that IRS guy. Why would she stay with her if he knew that? Why would he stay with her if he knew that? Because he's the perfect husband. He's the perfect father. The story doesn't hold up. The more I think about it, the more holes there are. He only needs one person to believe him to get this case yeeted. We all don't believe him, but could have gotten just a slight hold on any one juror. Possibly Bad Mouse Vinyls. It's a possibility. There obviously are going to be, as we're describing lifestyles that aren't familiar to all of us. They are familiar to some of us, and there might be a juror on that panel that does say, yeah, that rings true. Hey, this is RA. Who's on the phone?
Angela, sorry, my phone glitched for a second.
I have to ask, is your brother okay? Is your brother okay?
Yeah.
Okay, good.
He is a teenager that loves to,
Yeah, teenager. Stop. That's all we needed to hear. What was your thought here? Just got a couple minutes.
The thing that he said that she was enjoying, because she worked with SA victims, and she did examinations and victims who were assault, so she enjoyed that, and that's why she wanted to be the rest while they were in New York, and that's why she wanted to do that again, if I remember correctly. That's why he thinks. But if you ask anyone, and I know there are people in the chat right now who are in the medical field, that at least people I know that I have heard with my own ears, they do not want to watch any kind of medical drama. They do not want to sometimes I know a few people who told me that sometimes when it's a hard day at work, they go home and they have nightmares that what they saw will happen to them. So please explain to me, where is the logic? And that's everyone that I heard from. I don't know if everyone was like, at least people I met saw that to me, or I heard them say to other people. So please explain to me how someone who has worked and who has seen firsthand what certain things can happen to to people.
The impacts, the effects, the results.
Yeah, can go home and do that. I mean,
Yeah,
please
sign me up.
explain the logic to me. Please explain the logic to me.
Not just sign me up, but go full to the extreme of sign me up and put me at a situation where I have no control over the outcome. Okay, knowing as a medical professional how some of these outcomes end up for victims, whether they're willing or not. Some of the injuries that can be sustained and then the damage and the harm. Really? She's like, yeah. The less I know, the better. That's where she went. Make it the most extreme possible. This is such a deviance from everything else we know about her life. Planning family vacations and talking with their friends and maintaining, good work relationships and everything else. It just doesn't fit. It doesn't fit at all.
Not at all. I mean, it does fit if he has watched a little too many crime shows and TV shows, and I mean, seriously, I have been an ambassador for
judges back.
Okay, never mind.
Sorry,
Do you want to wait till after the rebuttal evidence?
Oh, I'm sorry. Okay.
Yes.
Yes.
Let's give them a chance. Okay.
Let's give the other ones a chance. Okay, here comes rebuttal. This could be quite interesting, especially if defense basically is getting blindsided by this, by somebody showing up last night in the prosecution's inbox saying, "Hey, have I got something for you?" I don't know. I believe that's probably true.
Commonwealth's rebuttal evidence.
Thank you, Your Honor.
T. Smith. T. Smith.
Your Honor, the Commonwealth would call Detective Stephen Augustine.
Detective Augustine.
Detective Augustine.
Please, raise your right hand. Do you swear or affirm to testify truthfully in this case under penalty of law?
I do.
Thank you.
Big smile for the camera.
Good afternoon. How are you?
Good.
Can you please state and spell your name for the court record?
Sure. Detective Stephen Augustine. That's STEPHEN AUGUSTINE.
Thank you, Detective Augustine. And can you tell us what it is you do for Fairfax County Police Department?
I've been a law enforcement officer for 24 years, the last 20 of which I've been with the Fairfax County Police Department. The last 12 years I've been a detective in the Technical Investigations Unit, Forensic Audio and Video Section.
Can you tell me about your training and education that led you to forensic audio analysis?
Sure. I possess a master's degree in audio technology as well as a master's degree in forensic science. Prior to my career here at Fairfax, I was a full-time instructor at American University in the audio technology department, teaching audio technology, electronics, and digital audio.
Have you previously testified as an expert in forensic audio analysis?
I've testified as an expert in forensic video analysis. I'm not sure if they qualified it as audio and video at the time.
All right. Is there anything about video analysis and your training for video analysis that differs or limits your ability as an audio expert?
No.
All right. Judge, at this time, I'm going to offer him as an expert in forensic audio analysis.
Any objection? Sure.
Okay, let's see if you can get in as an audio expert here. I know if you edit video, you edit audio as well. Those just go hand in hand.
Good afternoon, Mr. Carroll.
Sir, you heard Nick Barrero testify, correct?
I did.
Okay, and in terms of some of the concepts that he was talking about, are you familiar with those?
I am.
Okay.
Yes.
And so you've worked with and you're familiar with spectrographic analysis?
Yes.
Okay, and how many times have you worked in that capacity in the audio side of things?
On the audio side of things, for the past 12 years, I've done all of the forensic audio examinations and analysis for the police department.
And does that work, is that related to, and have you used spectrographic analysis in all of them?
No.
Okay, so what are the circumstances where spectrographic analysis is utilized?
In this particular case, he used it to provide a visual representation of what the audio was, what the sound was. So you're able to visualize what the sound is.
And in your 12 years on the police force and working in this capacity, have you done that before?
Spectral analysis?
Yes.
No.
Okay. Is that a tool that's used by people that are audio forensic analysis?
Sure, it can be a tool, yes.
Okay. Have you used waveform as a methodology?
Yes, waveform analysis, yes. I'm familiar with spectrograph analysis as well.
Okay, but you've used waveform. For example, when you're doing what he did on a case, you're using tools. You didn't use spectrographic analysis in any previous case, but waveform?
Yes.
Okay, and so would that be something that you would utilize on a regular basis?
Yes.
Is that something that's crucial to audio analysis?
I wouldn't say it's crucial, but I think it's common across all the forensic audio software.
Now, did you hear him discussing fundamental frequency informants?
I did,
okay.
Yes.
Did you agree with that?
I agreed with scientific principles, yes, that he presented.
Now, in your analysis over 12 years, did you use those scientific principles of fundamental frequency informants?
Yes.
Now, in this instance, did you do an independent test regarding these sounds?
I looked at him via the waveform, but I was asked by prosecution to look at his exemplary report and comment on what he had provided.
So there was no analysis done with regard to the known quantities?
There was no further analysis done aside from critical listening.
Okay. Judge, I don't have an objection to him as an expert.
All right, so we'll move him in as a forensic audio expert.
Thank you. All right. Now that you're an expert, can you tell us about your analysis of the defense work in this case?
Sure. I don't have a copy of the work in front of me, but the first few pages are just stating properties that were used in his examination and his forensic analysis, which include waveform analysis, spectrographic analysis.
And did you draw any conclusions from your review of the materials regarding the likelihood of a, let's call it, match between the Lilly 3 sample and the exemplar from the 911 call?
I did not hear him state that it was a match. He stated in his testimony that it's consistent between the two samples, which I concur, but there's also some further explanation that I think.
What is the further explanation that you think is warranted here?
Would it be possible for me to see a physical copy of the report?
The entire report or just the spectrograph?
Spectrograph is fine.
Judge, if I may approach the witness?
Yeah, you've seen this, I assume?
Yep, I'll give you one.
Everybody gets a copy of the spectrograph. It's just a squiggly line on a page. Frequency. What's the frequency, Kenneth?
Thank you.
All right, so let's talk about this. Do you recognize that document?
I do.
Okay, what do you recognize it to be?
This is a concatenation, which is a fancy word for stitching of the two files, the exemplar and the 911 call.
All right, and specifically that type of demonstrative, what is that?
This is a spectrograph, which is what we had discussed.
All right, and that's the spectrograph that was created by Mr. Barrero, the defense expert, is that correct? All right, Judge, at this point in time, I would offer that as Commonwealth's. Forgive me, please, just a moment. Let me get to my exhibits folder.
You use a concatenation to counter incantation, right?
Judge, that would be Commonwealth's 252.
252, any objection?
What? I believe this would be hearsay for him. He hasn't done any work on it. He's indicated he doesn't use spectrograph.
Not hearsay. I'll overrule the objection.
So what observations did you make in your analysis of the defense expert's work?
Sure. If I could clarify.
Foundation.
I can certainly ask some more questions if we need. Let's talk about that piece of evidence specifically. Are you aware of how it was created?
Yes.
Okay, can you tell us how it was created?
Sure. The gentleman uses isotope audio, which is similar to Digidesign, Pro Tools. There's numerous software companies that have the ability to edit audio files. What he did here, as I stated, is he's using a visual representation of the sound file. So, as you can see here, they show the different formats, which he also stated as overtones or harmonics that are present within the sound signals, both sound signals.
All right, Judge, at this time, I would offer Commonwealth's 252 into evidence.
All right. All right. Overruled. All right, 252.
All right. Please continue. What
Sure.
were your observations?
So my initial observations were that in the exemplar, aside from the fact that you had mentioned that there was over 5,100 seconds of audio, there was a 6-second sample that was used from the Lilly WAV file to compare to the 1.4 seconds that is shown here from the 911 call. Just to explain formats and overtones a little bit further than the other gentleman did, the fundamental frequency, which is the lowest frequency that he stated in this particular case, is 200 hertz.
Yep, it's a boy.
So what you would expect to see if you had a sound, if it wasn't coming from a signal generator or some sort of pure tone that illustrated a perfect sine wave, you're always going to have overtones. For example, in both of these, at this point, at this juncture point, they're both the fundamental tone, or F0 as he referred to it as 200 hertz. What you would expect to find in any sound source minus a pure 200 hertz sine wave is overtones. Where those overtones occur, they occur on multiples. That's what he means when he's referring to formats. So here you have 200 hertz, your F1, your first format, 400, 600, 800. So the fact that two different audio files look similar because they're displaying the same overtones is normal for a 200 hertz sound if it's not a pure sine wave. And the other thing that I wanted to illustrate on this, can I fold this?
Please do.
Okay.
Can I tear it in half? Please do.
So at the juncture point where he concatenated or stitched the two audio clips together, if I can demonstrate, if you can see this while I'm talking.
Please, this is awesome.
This is a 7.5 second clip, the first 6 seconds. or his exemplar, the dog, Lily, moaning. This portion, if you can see it, is 1.4 seconds of where he took it from the recording. So if I do my best with holding and lining up, I think you can see here, I'm trying to keep it still. Nothing lines up until it gets to that specific point in time. Something else that I noticed that the gentleman didn't mention in his testimony, when listening to his exemplar, the concatenation of the two sound files, there was no delineation between the two files. So I looked at it on waveform analysis and zoomed in on the waveform so I could see if there was any separation between the two files. And there was no point that I could see where there was any sort of ending to the first and beginning of the last, which to me would reflect that what was likely used when concatenating the files is what's called a crossfade, an X-fade. So as the first exemplar, the Lily file, fades out in volume, the other file, the 911 call, is coming in. It's almost a mixture of both sounds, which makes it sound like one continuous file.
That means they blended it intentionally.
When you tail off into the 911 drone.
So what would we have heard differently if he had not used the crossfade?
Best practices, you would have heard a full 6 seconds of the exemplar, which start at varying pitch. There's quite a bit higher than the groan that's represented in the 911 call. And you would hear the point where they separate, and you would hear the two different ones to compare to.
Thank you. I'm going to shift gears here for a second. When were you asked to first examine these sound files?
I believe I received an email from Detective Bryant on September 29th of 2025.
Okay, so approximately a year and a half, almost 2 years after the murders were committed. Is that correct?
Correct.
Okay. So when you were presented with these clips, the 911 clip and the Lily clip, were you given any background information about the 911 clip to further your analysis?
No.
Okay. Have you ever had the opportunity to watch any of the recorded statements of Juliana Perez Magalhaes?
No.
Okay. And did you witness her testimony here in this trial?
I did not witness her testimony. It wasn't until yesterday that I was released from viewing or discussing the case.
Okay. So when you performed your analysis of the 911 recording, specifically the hang-up, is it fair to say you didn't necessarily know what you were listening to? Absolutely. Did you know what you were listening to?
Sustained. I knew what case it was affiliated with.
The objection was leading.
Sorry, say that again for me.
I knew what case that it was affiliated with, yes.
Did you know if anyone was expected to speak in that recording? Did you know
No.
what to listen for?
No.
Okay. And how did you perform an analysis of that 911 hang-up call? What did you do with it?
I put it into Avid Pro Tools, which is audio software very similar to Isotope, what the other gentleman was using. And I looked at the waveform, and I did a waveform analysis and critical listening of the files.
And based on the waveform analysis and critical listening, what did you observe?
I observed, audibly, I heard the 911 telephone call and the computerized voice that's referred to at the beginning. And the operator asks, where is your emergency? And upon inspection of the waveform, I saw that there were sounds present prior to the groaning sound that is heard on the 911 call.
Okay, so you're indicating in between the cessation of the 911 operator speaking and the beginning of the groaning, you heard something or you saw something.
Correct.
Okay. Did you dig into that?
I did. So what I did is I separated that portion of the audio where I thought I heard something, and essentially in Avid, it's called clip gain. And on that one portion of the 911 call, I was able to raise the volume.
Just crank the volume.
What was heard just prior to the grid.
Let's hear it.
And were you able to make out a human voice?
I heard what I believe to be a human voice, yes.
Ooh,
And what did the human voice say?
Hang it up. Okay, if they get to say this, I bet it's hang up. This guy is not doing the way he's doing his analysis. This is not a studio level. You know, you need a doctorate degree to do this. Most people can do this with their home computer and some basic editing software. He's talking about Avid, which is a video editor. Okay. You could do it with Pro Tools, which is a lot more high end. You could do it with Blackmagic Design's DaVinci Resolve, which is free. You can do all this. You can find a little bit of sound. You can look at it in the waveform. You can crank that audio level really high. You can really turn the gain up, especially if there's not any other sound there to like blow out the speakers. We might do this if they don't allow us to play it. I might do it for you if we can find the recording. By the way, the crossfade that I just about choked on my drink over is something where basically you've got two audio sources playing at the same time, and if you very slowly turn up the second audio source, you don't notice it until it's starting to be there. You don't really know when it started or where it ended. For example, right now, a few seconds ago, I've actually started slowly turning up a music bed underneath my voice, and I'm slowly grading the volume as we speak. If you listen carefully, you might hear it. If not, it's like, oh wait, well, there is something there. All right, how long has that been there? When did it start? Of course it sounds smooth when I blend it in like that using a crossfade. That's basically what he's accusing the defense expert on doing, blending the sound in so it's all smooth and it sounds like you're listening to the same thing. So there's no harsh cut between when the music is playing and when it's not. Right? Because it would be jarring if we heard the sound. It's like, oh, that was dog, and then that wasn't. He's saying, no, this was a blend. This was a blend, and that's terrible. It's terrible for an expert to do. If he did that, I'm not sure he did, but that is not expert level. That's not how you do it, right? This is how you would finesse the evidence to make it look like it's the same when it's not. So it's quite the accusation against the defense expert. All right. It's dirty. It's dirty. It's like objection. Somebody doesn't need to be an expert anymore. All right. I hope they get to play this. Because otherwise we have to dig for the 911 call, and I have to do the editing myself, which we can do. I'm guessing, because I can tell you, I remember when I heard this audio call and I listened to that point in the call, I thought there was some whispers in the background. I thought there was what I heard was vocal in the background, like voice, somebody either saying something far across the room and being captured, or somebody saying something very quietly. But I haven't gone back and listened yet. So, all this is over 1.4 seconds of sound. And now the part we're talking about right now, Laurie, is actually the part that comes before the 1.4 seconds of sound. But I don't know how they can keep this part out if the expert's saying I basically analyzed what came before it. Maybe they're saying this is a new revelation. This is not turned over to defense. Discovery issues? Could it be that? It could be discovery issue. And kept out for that reason. The cure for that might be, they might say, Your Honor, we just barely heard about this ourselves yesterday. And maybe we wait till tomorrow. We get a break today and finish it up tomorrow. Yeah, it's on the level of inverted. If it was intentionally inverted video, it's very similar.
All right, I think we do not have any further questions of you, Detective. Thank you so much. Please answer any questions that counsel might have for you.
Examination.
Somebody send me the audio from the 911 call, please. If you've got a clean copy, I'll do that work for you.
Detective Augustine, what you've just shown is something from my expert's report, and it's a spectrographic analysis. Isn't that correct?
That's correct.
Okay. And you testified previously in the voir dire that you don't even work with spectrographic analysis, correct?
I stated that I'm familiar with spectrographic, but it's nothing that I've done prior.
But you don't use it as a tool in your analysis, correct?
It's a tool that I have available, but I haven't used it in the case.
Okay, and so in terms of best methods, is it appropriate to fold a piece of paper in order to make a comparison as best methods?
I determined that was the best visual way to represent it that would make it understandable.
Okay, and was there any effort at making a presentation to support whatever your conclusions were today, other than folding the paper?
No, this is all I was presented with and instructed to have my comments on.
And when were you presented that?
I believe I stated September 29th is when Detective Bryan sent it to me.
So, okay, so let me understand this.
Sure.
So you were just given one picture and asked to make an analysis?
I was given a complete report from the gentleman's forensic analysis, and I reviewed the entire report.
Gotcha. And did you prepare a report?
I did not.
Were you asked not to?
I was not asked to prepare a report. I was asked to comment on his findings.
Would it be best practices in the world that you're in to have prepared a report to something?
I'm going to object. It's argumentative and irrelevant.
Overruled, good.
Speaking about best practices, would it have been best practices to create a report with whatever findings that you wanted to tell the ladies and gentlemen of the jury?
If I was instructed to do my own analysis, a separate report from this, I would say yes. But as reviewing this as a rebuttal witness, I didn't believe it to be necessary.
But you work for the Fairfax County Police Department.
Correct, sir.
So they could have asked you to do an analysis on your own.
Objection calls for speculation.
Sustained at this point.
You have the capacity to do a full analysis if you were asked, correct?
Yes, sir.
Okay. And do you recall who got you involved?
Objection, relevance.
I'll sustain the objection.
Was it Detective Bryant?
Objection.
Sustain the objection. I'll sustain the objection.
Vince just barges ahead as if, and then he drums his hands on the.
I don't have any further questions, Judge.
All right, redirect.
Nothing, Judge. Thank you so much.
All right.
That's witness number one. It's supposed to be 10 minutes, took about 20.
Patrick Smith.
Patrick Smith.
This is tea. This is tea. Spilling the tea. And it's the final witness for rebuttal.
Sure.
Defense wants to approach on this one as well. This is the one we heard about first thing this morning, saying, Your Honor, somebody's called us up and said, we have something you need to know. We've been following this case, and we need to know. We think he is an investigator with the IRS. We think that this witness who's walking in right now is a former coworker, would be my guess. So let's see how this goes down. He looks IRS. He's got that IRS. He's got that bean counter tax collector look to him. You know, if you know, you know. I remember the testimony that we had from Brian Banfield about the days he was traveling while he was away and when he was on trips, and he went to the firearm training center. This might be somebody from the firearm training center saying, actually, he wasn't here. He wasn't here that day.
Want to come forward, sir?
Raise your right hand. Do you swear or affirm to testify truthfully in this case under penalty of law?
I do.
Thank you.
It was actually 8 minutes. He's here to testify. Here we go.
Good afternoon, sir. How are you?
Good afternoon.
Can you please state and spell your name for the court reporter?
Thomas Patrick Smith, ThomasPatrick
Thank you. You can pull the mic just a little bit closer to you. Thank you. Do you know Mr. Banfield?
I do.
Okay, and in what capacity?
I'm a special agent with IRS Criminal Investigation, and Mr. Banfield was previously employed with IRS Criminal Investigation at my office in Vienna, Virginia.
Directing your attention to February 23rd and 24th of 2024, in that time period, was he your direct supervisee?
2023?
I'm sorry, 2023.
Yes, on February 24th, 2023, I was the acting supervisory special agent for the Vienna group.
All right, and so did Mr. Banfield report to you?
He did at that time, yes.
All right. Was there anyone else that he reported to during that period of time?
Juliet Jones was the permanent supervisory special agent, but she was out of the country, and IRS practice is that someone is designated to be the acting supervisor when the supervisor is unavailable. So in that particular time, I believe I was the acting supervisory special agent from February 15th through February 24th. Juliet returned on Monday, February 27th.
There was no meeting.
All right. To your knowledge, was there a meeting scheduled between yourself or with Juliet and Mr. Banfield on the morning of February 24th, 2023?
All right, leading.
Sure.
Sustain the objection.
Did you have any plans for the morning of February 24th, 2023?
I did. I was in Baltimore on an unrelated undercover operation on that morning.
Were you scheduled to meet with Mr. Banfield?
I was not.
And again, I'm sorry, where was Juliet, his other supervisor?
She was out of the country.
Okay. Mr. Banfield testified that he was meeting with his manager. Is there another person that could have been?
As you go up the management chain, we have an assistant special agent in charge. His name is David Meisenheimer, and we have a special agent in charge, Kareem Carter, and they were both in, I believe, Georgia at the time. Because
and Georgia, the state, not Virginia.
Correct.
Okay. Within your industry, is it commonplace to appear for career? Sure thing.
All right, Sustain.
How does one dress in the IRS when they are approaching a business meeting that is imperative for their success and potential promotion?
Jeans.
Well, we could say that when I have important meetings, I dress in a semi-formal or formal, like suit and tie, or at least, nice slacks and a shirt.
Would jeans or tennis shoes be acceptable?
I have never worn jeans or tennis or sneakers or tennis shoes for important meetings.
You have to put your microphone on, Mr. Carroll. What's your objection?
Objection to the relevance of this. He's indicating what he does.
Overruled.
All right, thank you. Did you speak with Mr. Banfield on the morning of February 24th, 2023?
I did not.
Okay. Were you surprised that he wasn't there at 8 o'clock?
Again, I was in Baltimore, so I wasn't there, but I was surprised when I received a phone call indicating that Mr. Banfield had discharged his weapon and there were 2 deceased persons, which, as you would imagine, that triggered many responsibilities as the acting supervisory special agent too.
Understood. Just as a law enforcement professional trained by the IRS, do you share your gun safe code with your family members?
Objection, Your Honor, it's not relevant and it's leading.
Sustain the objection.
Oh,
All
it
right,
should have been
thank
allowed,
you.
though, because the
Nothing
defense
further.
opened the
Please
door.
answer any questions council might have for you.
Cross-examination.
Thank you.
Brandon is not looking at him. He's busily writing something very important on his notepad.
I'm sorry, sir. Tell me your name again.
Special Agent T. Patrick Smith.
Okay. And you were, as I understand it, you were the special agent in charge while Juliet Jones was gone out of the country?
No, I was the acting supervisory special agent.
Okay. And so that was something that she put you in charge of, or someone higher than that?
I believe she was able to designate, but you'd have to check for sure. But I'm sure she had upper management approval for who she designated as the acting supervisory special agent.
Okay, so so you said something like what happened where he discharged his firearm and there were 2 people dead. That caused a lot of work for you?
When I was informed by the Fairfax County detective as the acting supervisory special agent that one of the agents in the group had discharged his weapon and there were 2 deceased persons, then yes, I had to contact upper management, which I did. We had a process. The Treasury Inspector for Tax Administration, which we call TIGTA, is essentially our internal affairs. They have to be notified. They do an investigation to determine if the discharge of the weapon was appropriate.
Okay, I guess my question was it extra work for you?
Was it extra work for me?
Yeah, isn't that what you just said to the ladies and gentlemen of the jury, that when this situation arises, it becomes a great deal of work for the person who's the acting special agent in charge?
Well, yes, I had to make several phone calls. I had many conversations with people that I would not have had if there hadn't been.
Okay. Now, did the Fairfax County Police know that you were the acting special agent in charge?
I can't really speak what the Fairfax County Police knew, but I did speak with a detective from Fairfax County Police.
Who was the detective you spoke to?
I don't recall the detective's name.
Did you ask him his name?
I knew it at the time. As we speak now, I don't recall.
So there was no report to the people that you called and people that you told about this?
Objection calls for speculation.
Overruled, if you can answer it.
There was no report that you created to talk about this situation, which made a lot of work for you, where you would put in the detective's name?
I definitely provided that information to upper management, and if I could access my emails, I'm sure that's in there.
So in your capacity, did you stay within the Vienna office after that when Juliet Jones came back?
Did I stay?
Yeah, were you still in the Vienna office when
I currently am still in the Vienna office.
Okay, so from that time until now, you're still in the Vienna office?
Yes, that's my permanent post of duty. I was there before that day as well.
Now, there were 6 people that were interviewed relating to TIGTA interviews. Actually, I'm sorry, there were 8 people that were interviewed. Do you know the name David Meisenheimer?
Yes, he was the assistant special agent in charge.
Were you aware that he was interviewed by Detective Vesser of Fairfax County?
I don't.
Okay.
Necessarily know, but.
Do you know Lawrence Flagg?
I do. He's another agent who was assigned to the Vienna POD on that time.
Okay, and were you aware that he was interviewed as well by Detective Vesser?
I believe he told me he was interviewed. I don't know. He disclosed the name of the detective.
Now, do you have team assignments in terms of the IRS?
I'm not sure I understand the question.
Is there someone named Carrillo that has a team in the Vienna office?
Carrillo?
Yes.
I don't recognize the name. Can you spell it? Maybe it's the pronunciation.
Carrillo.
I don't recognize that name.
Okay. Would it surprise you that Juliet Jones, who actually wasn't even there on that day, was interviewed by the Fairfax County Police Detective Vesser?
It would not surprise me that Julie Jones was interviewed. She was the supervisory special agent.
Now, Detective Carter from the Fairfax County Police, did you have contact with him?
I don't know.
Okay. Well, there were
I think Special Agent Daniels did mention that, yes.
Okay, and Philip Hammond, do you know that person?
Yes, I know Special Agent Hammond.
And did you know that he was interviewed by Fairfax County Police Detective Carter relating to my client's case?
I believe he also told me he'd been interviewed, yes.
Okay, so you knew about that?
Yes.
Okay, and so when you heard all these other people were being interviewed, did you ever say, well, hold on, I was the special agent in charge for a period of February 13th to February 24th?
February 15th.
February 15th to February 24th. You didn't raise your hand and say, what about me?
I did.
And so they chose not to interview you?
I'm not exactly sure what happened, but
Okay.
I was out of town the week that the interviews took place in our office.
Oh, so you're aware of these interviews. What week did that occur?
I'd have to look at my calendar. My best guess, things like you have it, is March 2024.
Okay. How about Detective Lynch from Fairfax County interviewing Justin Williams, a special agent?
Justin Williams is another agent in the group.
Did you know he was interviewed?
I think he told me he was.
Okay. And these would have been, other than Juliet Jones, these would have been people who were subordinate to you, correct?
At the time I was acting supervisor special agent, technically, yes. I mean, I view them as coworkers who are all special agents.
Okay, so you're all on the same line unless you get dubbed the acting special agent?
Correct.
Okay. And finally, Kevin Farley, do you know him?
I do. He's another agent in the group.
Okay. And the interviews that were conducted were relating to relationships of Brendan Banfield. Did you hear about that?
I did not.
Marriage problems with Brendan Banfield. Did you hear about that?
I did not.
Rumors that were going around in the IRS. Did you hear about that?
What rumors?
In the context of these interviews, they were being asked if there were rumors.
I have no recollection of being told of that, no.
They were talked to, the individuals were all spoken to about schedules that occurred in the Vienna office. Did you know about that?
An interview that I was not present at, I don't know what was discussed.
Well, that's what I'm wondering. I mean, you were the special agent in charge.
I was not when these interviews
Objection,
occurred.
argumentative.
Sustained, next question.
Okay. Now, there was discussions in these interviews about the types of cases that everybody worked.
Objection, speculation.
Sustained, next question.
Do you know what these interviews were about?
I do not know what occurred in an interview I was not present at, no.
Okay. So you were there and for 2 weeks in that capacity, correct? 15th to the 24th.
Again, I was acting supervisor special agent for the Group 1 of the Washington, D.C. field office from February 15th, 2023 to February 24th, 2023.
Okay. And in that, you're coming in here to this courtroom in that capacity to tell the ladies and gentlemen of the jury that, I guess, there are issues with that you dress a certain way. Is that right? When you're going to the office?
Are you asking me how I dress when I go to the office?
Well, no, you've already testified to that, but you're here testifying, and one of the things that you've said is that you dress in a different way than what was described of my client when he was going to the office on February 24th.
That is correct.
Okay, and you indicated you were in an undercover operation, correct?
I was assisting with an unrelated undercover operation in Baltimore, Maryland.
And undercover operations have its own command staff outside of the Vienna office, isn't that right?
I don't know that I would characterize it like that.
Okay. Are there undercover command staff that handle undercover operations that aren't in the people that I just listed off to you that were interviewed?
I'm unclear in your terminology, but yes, there are people who, we have a whole special investigative techniques group that's involved with undercover operations.
And they would be the people that if you have an undercover operation and you're talking to an undercover person, that you would be working with them, correct?
Not really, no.
Okay. In your undercover operations, when you're interviewing undercover operative, do you into the office to talk?
I don't interview undercover agents. I'm confused. I'm a lead tech agent for the Washington, D.C. field office. So the traditional undercover operation where they get wired up and they have equipment and they're covertly recorded, that is my job. So I'm involved with that, and then preserving for the chain of custody the evidence that's obtained during that meeting.
What about undercover operations that deal with other issues, relating to IRS criminal investigations?
Judge, objection is to form. I don't think the question makes any sense.
Rephrase.
What about undercover operations that would deal with specific areas of criminal fraud? How are they handled?
I've only been involved with undercover operations conducted by IRS criminal investigation.
Okay.
And they've virtually all involved fraud. So.
And so the undercover operations that other people do, are they different than what you're within the IRS?
Judge, objection is to relevance. I'm not sure where we're going with this at this point.
I'm just trying to get to the background, get to his background, Judge.
I'm going to sustain the objection. Next question.
Now, sir, would you have known where Lawrence Flagg was on the 24th of February, 2023?
I do, because he told me.
Okay, were you keeping track of him otherwise?
Yes, we were in regular contact throughout that day.
Okay, and that was because of the incident that occurred at the Banfield house, correct?
Correct.
Prior to the incident happening, would you have been in contact with Lawrence Flagg on a regular basis?
Can you define regular basis?
Well, you tell me. How often do you have contact with him?
He's an agent in the group. As a regular agent in the group, I would see him probably whenever we were both in the office. As a supervisor, I would have contact with him as needed.
And so how many times did you have contact with him as a supervisor during that week?
I cannot recall the days before February 24th, 2023, but on February 24th, 2023, I had many phone conversations with Lawrence Flagg.
Okay. I don't have any further questions.
All right, redirect.
Wow. There was no meeting. He was not headed to the office.
Just for clarification, was Lawrence Flagg Mr. Banfield's supervisor?
No.
Okay. And when Mr. Banfield testified that he had a scheduled meeting with his manager, that would have been yourself or Juliet Jones. Is that correct?
Those are the only two people that have been his manager. Yes.
Okay. And she was out of the country, and you were in Baltimore and not planning on meeting him, correct?
Correct.
Okay. Nothing else. Thank you, Judge.
All right, sir, you're free to go.
Judge, may I ask one more question?
No, sir.
No, sir.
Are you free to go, sir?
No,
All right.
sir.
Your next witness?
Commonwealth arrest.
All right.
Boom,
Ladies
they're
and gentlemen,
done.
The Commonwealth has arrested the rebuttal evidence. So in other words, you have heard all the evidence you're going to hear in this case.
It's time to do a
So
poll.
what I'm going to do, we have some housekeeping matters to take care of. So what I'm going to do is release you early today. And what we'll do is when we come back at 10 a.m. tomorrow, you will hear closing arguments, and then the case will be handed over to you, okay? All right, so have a good night. Do not discuss the case. Do not do any outside research, please. Okay, thank you.
Do the indictments pulled up? Do you know which counts were striking?
Okay, the part they're going to talk about, they're going to drop two of the charges right now.
All right, Mr. Carroll, now your motion.
Mr. Carroll's got a motion here. They're going to drop two of the charges. That's normal. There are 4 murder charges. They're dropping 2 of them.
Your Honor, renew my motion to strike previously given. In addition,
Right.
Denied.
Thank you.
That's denied.
I'd renew my motion to strike previously given at the light most favorable to the Commonwealth, expecting that evidence would come to light regarding the investigations in this case. It would come to light regarding anything that would appear other than the co-defendant, who has every possible incentive to tell the story that the Commonwealth has asked her to tell. Once again, not in the light most favorable to the Commonwealth, we're here at the end of the evidence. The testimony by the co-defendant, who appears to tie everything together for the Commonwealth, essentially was a story that, when pushed and questioned, couldn't do anything but say, I don't know. And in fact, at one point, as I asked questions regarding details, and as we know from listening to the lengthy evidence relating to digital forensics, the lengthy evidence relating to blood stain pattern analysis, these require details, and this Commonwealth's case is entirely devoid of details. You've heard from many detectives who were in the defense case, specifically Detective Miller, who was their expert, the expert that they chose not to use. And in that, he indicates that the data, he still stands by the data relating to his executive summary. The only thing that changes is that Juliana Perez Magalhaes decided to come forward. Once again, if someone's coming forward, there has to be some sort of way to test their knowledge, test their timing, test by the dates that are crucial to this case. And in every, despite the fact she walked through with the Commonwealth whatever the story was going to be, she couldn't answer any other questions, or she wouldn't answer any other questions. Judge, with all due respect, it was my position, and we did it. We put on the evidence through the Commonwealth's witnesses, and many of them are in absolute conflict with what she said. This whole entire case rests on her testimony, and rests on her testimony relating to the timing of her trial, the timing of her the health illness, the timing of Brendan's arrest, and the timing of her feeling like she'd lost the ability to defend herself because of whatever she says about her lawyer. I'm not saying that's true, but it was certainly something that she was thinking of. In fact, we saw numerous messages where she talks about almost giving up hope, because if he asks for another continuance, then I don't know what I'm going to do. And so, Your Honor, given all of those facts, and no longer in the light most favorable to the Commonwealth, I'd respectfully suggest that Your Honor strike this case.
It still isn't the light most favorable.
The motion to dismiss relating to NAPU, it still even more so relies upon what I believe to be testimony that's not truthful, and can be shown, and has been shown to be not truthful in numerous ways. And I'd respectfully ask that you consider the motion to dismiss.
All right, thank you, sir. Yes, ma'am.
It still has to be looked at in the light most favorable. It's
Your
the
Honor, in the
non-moving
light
party.
most favorable to the Commonwealth, we have met our burden. It's appropriate that the case be submitted to the jury. Thank you.
Amen.
All right. In this matter, not weighing the evidence, but the evidence that's before the court, there is a scintilla of evidence for each of the counts. There's 5 counts in 2024-666, and there's 2 counts in 2024-873. And there is evidence that can go forward to the jury. The weight that they put on it at that time is up to them. And and as far as the dismissal under NAPU, I again will deny that motion, as I don't find it as as a matter of law that the co-defendant's testimony is incredible. Again, that weight goes to the jury. So based on those statements and what was stated in the record for the previous motion to strike. Your motions are denied, okay? All right, so jury instructions.
Your Honor, initially, if the Commonwealth may be heard, and I'm going to turn this over to Ms. Frissler because she has the indictments pulled up. As I'm sure the court knows, the Commonwealth cannot proceed with sentencing on both an aggravated murder within 3 years as well aggravated murder for commission at the same time. At this point in time, we would elect to go forward on aggravated murder for 2 offenses committed within 3 years, and between the 2 child endangerment and abuse and neglect, we have elected to move forward with endangerment. Ms. Frissler can address which.
Okay, just so I get this straight, I mean, the case law is that both Section 7 and Section A can go back to the jury.
They can, and then if they find guilty on both.
Sentencing, I just sentence on one.
Correct. We, at this point in time, feel that it would be less confusing for the jury to simply submit
It's your case, so.
the offenses that we believe we've met the burden of proof for.
Okay, so which ones are you going forward on then? I guess that's Ms. Frissler, sorry.
Judge, we, in case number ending 666.
Yes, ma'am.
So we have counts 1, 2, 3, 4, 5.
Yes.
So Judge, if we strike counts 1 and 2, those being the aggravated murder charges within the same transaction.
Count 1 and 2?
Yep.
When you say strike, do you mean dismiss?
Yes.
I assume no objection? All right, count 1 and count 2 are dismissed?
Yep, that would leave us with counts 3, 4, and 5 in that case number.
Okay.
Then, Judge, if we look to case number ending in 873.
Okay.
And in that indictment, if we look to count 2.
All right.
Count 2 would be the
child abuse.
Abuse and neglect.
Yes, that would be the one that we would strike.
So you're striking count 2, or dismissing count 2?
Yes.
Any objection to that?
So he'll be facing
All right, so we
4
just have
charges
count 1
instead of 7.
873, which is child endangerment, correct?
Yes, ma'am.
All right, so based on that, we need the charging instructions then
Gonna throw a few of them out.
for the 2.
Does that make sense to everybody what they're doing right here?
Okay, here's the next question I have for you. So count 3 and count 4 are legally the same. Yeah, I mean, if you look at the charging instruction for aggravated murder, you're just switching the names, but you still have to find premeditated murder, correct? For both of them. So what's the difference between count 3 and count 4?
One is for the murder of Christine, one is for the murder of Joseph Ryan.
Well, but it's aggravated murder, so it's one charging instruction for both of them. The only reason it's aggravated murder is the killing of 2 people.
Correct.
Okay.
So you only read one instruction.
How can you have different charging instructions where you're just flipping the names? The one charging instruction would involve both murders.
And Your Honor, the way we drafted them was to say exactly what you just said, to flip the names. One is for the murder of Christine Banfield and one is for the...
You're not
In
listening.
order to have aggravated murder, you have to have 2 murders.
Correct.
So the charging instruction has to have both murders on the charging instruction, right?
Yes.
Do we want to look at the model jury instruction?
And we used the model jury instruction.
Right, so how can you have 2 of those?
If Your Honor does not, then we couldn't... Is Your Honor suggesting that we couldn't have 2 instructions or that we can't have 2 indictments?
Your 2 indictments are proving exactly the same thing. I mean, how is that possible? It's not for the murder of one and murder of the other. Aggravated murder is 2 murders. So you have one I thought, it's your case, but I thought it was what aggravated murder for 1 for 3 years, aggravated murder for 1 in the same transaction. But that's not what you're doing, which is fine. But
I understand.
I don't see how you can do 2 separate aggravated murders when you have to put the 2 murders in for aggravated murder.
Understood. And I see
waterfall instructions are different.
Sure.
Because you have first degree murder in one,
and then it
first
splits
degree murder
apart.
in another.
Right. And that's how we've written them, is to have a waterfall for each, so that if they find one can be...
What's the difference between the 2 aggravated murders, though?
Judge, I can look up some case law on this and take a minute, figure out the answer to your question, because I don't think I am...
I think I have it tackled here. I mean, aggravated murder for your section that you're going under is number 1, that the defendant killed name of both people.
Sure.
And number 2, that the killings, plural, were willful, deliberate, premeditated. And number 3, that they happened in a 3-year period.
Okay, understood. But then the indictment couldn't stand as 2 counts either.
Well, that's what
that's what you're trying to tell me. Okay.
The one for the same transaction can go back as subsection 7, and the one for subsection 8 can go back as 2 different aggravated murders. But how can you have 2 under subsection 8 going back as 2 aggravated murders?
But then what do we do, how does the waterfall instruction read when you believe that he killed Joe but not Christine? And
well, that's why you have to do a different waterfall instruction.
So what I was understanding Your Honor to suggest was that there would only be 1 indictment and 1 instruction for aggravated.
Right.
But wouldn't we then need 2 separate instructions?
Right, or if you find that he only murdered Christine Banfield.
Right.
At first degree, and you have to go down that, or move on to the next, you only found that, it would be the
But at what point do they diverge, right? Because if you don't find aggravated, do you then have a separate instruction for first degree for both? If you find Christine but not Joe, and if you find Joe but not Christine?
If you have not found aggravated murder, period.
Okay.
Then you may find first degree there, first degree here.
Right.
Is this making sense?
It is. No, I'm absolutely tracking what you're suggesting. I think that's not the way we've done it, though. So we should probably.
I just don't see, and I'll give you time to go look at some case law and see how 2 aggravated murders, because the only reason it's aggravated murder in this case is there's 2
Right, because there's 2 people.
Right, so I don't see how 2 counts of the same of 3 years goes to the jury when it's just the 2 people.
And I'll admit, Judge, I was just sailing with the indictments the way they were presented with 2 counts of each, 2 counts of within 3 and 2 counts at the same time. I will need to look into this to determine what the next step forward is.
That's not a problem. I mean, would you rather do this in the morning then?
Yeah, just to make sure that I have the correct answer rather than.
That's fine. I think that's fair. Do you have any objection to that, Mr. Carroll? Or anything you want to add to the conversation?
No, Your Honor, we were just chatting, and so I'm fine with looking into it.
Well, if you want to, and maybe I'm going down the wrong rabbit hole, but it's just.
Your Honor, I think it bears looking into. I think you raise a good point. If we can, however, then not yet strike counts from the indictment, we may still come back to that same position, but
that's fine. We can do that. So we can get this figured out.
Okay.
And if you come back tomorrow and that's what you want to do, that's fine. I'm just trying to keep a clean record here.
Understood. I appreciate that.
Can we have the 9:30 motion, so you want to meet at 9? Is a half hour going to be enough time?
That should be, because we will speak in advance of court tomorrow.
Oh, that would be, it's music to my ears if it's true. Okay, that would be fantastic. If you could meet ahead of time and maybe agree on whichever way you end up going on them, and we can have those charging instructions tomorrow, or whichever you go for. I'd appreciate it. Let's meet at 9 then. Let me go let Jamie know we need a court reporter for 9. Okay, great. And we'll be good to go. We'll see you at 9. Anything else at this time then?
Yes. This case is no longer obviously subject to enrolled witnesses. I think we need to let the jail know so that she can be returned
to her.
Okay, yes, to wherever she's returned
She
to.
was
not segregated.
She was segregated.
Okay. So yes, so she has been released. So we'll do a jail card or something to.
She's been in isolation.
Thank you. Okay. Appreciate it.
All right. Anything further?
No, Judge.
All right. We'll see you at 9 a.m.
Wow. That was interesting. That legal battle there at the end. It's the dotting the I's and the crossing the T's that we were running into problems there. What happened was the state indicted and charged these murders in a way that gave them options as to how they wanted to proceed with the case, as far as what they wanted to get convictions for. Because there are different ways to say you broke the law in this area. Just like we can either get you for speeding 55 and a 20, or we can get you for reckless driving. Okay. Because that speed in a 20-mile-an-hour zone, that's reckless. There are 2 ways they can go at this. And so they had the murder, and then they had the killing 2 at the same time, and they had the 2 within 3-year period. And it's weird the laws are written that way, but that's just the way they are. We have to work with it until they change them. And so they strike the killing 2 at the same time, go with the 2 aggravated murders, which the judge, after she accepts the yes, we agree, will strike it. The defense says no objections. She strikes it. I really wish they'd put up a fight there when they tried to bring him back. But then she says, no, so just tell me how you want this to look. Because under the law, aggravated murder is killing 2 people. You're charging him with aggravated murder for killing 2 people, and you want to charge him twice with killing 2 people. That equals 4. 2 plus 2 was 4. And they just were talking over each other and past each other for a while. Dismiss, not strike. You're right. Dismiss. They got undismissed. Judge is catching cold. Yes, she's been drawing from a box of tissue throughout the trail. We've caught her a couple times on camera doing that. And yeah, she's not feeling the best. But she's still on her A game, as you see from the sharpness. Her mental acuity is all there, even though she's probably feeling a little under the weather. In spite of that, we're going to be back again tomorrow and continue this case where we have jury instructions. I didn't hear them say the words, but are we doing closing arguments tomorrow? Did I miss that? Do we have closings tomorrow? I think we have closings tomorrow. And then the jury can either get their work done early and get out of there in time for dinner, or she said that, yes, okay, closings tomorrow. They're going to start at 9. We're probably going to start early as well, so we can hear how that case, or how the charging is going to be hammered down. They're also going to tweak the jury instructions based on the charges, so there's going to be a little modification there. That's not a big deal. All the big work has been hammered out already on that front. So tomorrow we'll be back. We'll have closing arguments, which should be good. It should be really good. I really want to see the prosecution put everything together, especially some of the issues they didn't cross Brendan on today, which I think they had the opportunity to do. Maybe overnight today they're going to look at his testimony and say, yeah, here's the glaring thing we missed. We can just wrap that into our story tomorrow as we're explaining this and putting it all together for the jury, and it'll be a no-brainer for them. So during the home by lunchtime. I don't think lunchtime will work with what they're starting late. And I'm pretty sure you're probably going to get at least 45 minutes on each side, maybe more. Remember, this has been 9 days of testimony. So I think we're probably going to have at least an hour and a half. The jury will get lunch. We have jury instructions as well, which are probably at least another half hour. Yeah, I'd be very, very surprised if the jury got to deliberating before 2 o'clock. So, all right. Anything else? No podcast tonight. I do apologize. No podcast. Thomas is under the weather. Thoughts and prayers for him as he's out still having to work and get things done when he's not feeling well. So we'll give him the day off. Give you all the evening off as well. And I have to go out to the Airbnb. I went to Lowe's this morning and picked up a whole bunch of pipe foam, like insulation. Because in the 6 years we've lived here, it's never gotten this cold. Now it's getting cold. We're expecting at least 2 to 5 inches of snow this weekend. We have never had snow last more than about 30 minutes after the snowstorm. It melts that quickly here. I mean, winter for us is when the dandelions are blooming. We're so far out of our element, it's not funny, but we're expecting 2 to 5 inches of snow. The weathermen, at least Brian Hollyall, he says, the pattern's up in the air. We're not sure exactly what's going to happen. The only thing we know for sure is that Greenville, North Carolina is going to get hit, and that's where I am. So have some thoughts for me this weekend. It's going to be a cold one and a pretty one, apparently. My kids are going to want to go sledding. We don't have any sleds or hills. It's flat. So thank you all. Appreciate everybody. Brian Hollyall. Yeah, Brian Hollyall. Ryan. Did I say Brian? I think I said Ryan. But anyway, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe till we go live again tomorrow morning. We'll be live about 8:45. We will be live here for the morning catch-up with how the case is getting decided at 8 a.m. or 9 a.m. And we're moving on from there. I've got to order this visualized spectrogram graphic equalizer meter thing. I think it would go right here on my desk. I think it would look great right there. Just have some little bouncing green lights. It'll be perfect. Yeah, that's what my desk needs, right? More lights. So you guys have a great night. We'll see you tomorrow. Be good to each other. Bye-bye.